When a parent's child turns 18, this is often considered a big milestone, both for the parent as well as the child. They are now considered an adult, and the world opens up to them in many ways that it hasn't previously. However, when your child has special needs or has a disability, this often can lead to some anxiety that you might not otherwise feel, because you need to look at the opportunities that they may have presented to them and what decisions they may or may not be able to make on their own to lead the life that they've become accustomed to in your care. This particular PowerPoint will discuss some of those considerations and provide some information so that you know where to turn to find the resources and the advice that you need and the guidance that you might need for legal issues relating to your child with disabilities. The first consideration is the power of attorney. Powers of attorney can be crafted specifically for your needs by an attorney. They do not have to be specifically what is listed in a sample such as the one that you're seeing now. They can be crafted very specifically to fit each of the needs that you have for your child as compared to anyone else's child. However, there are 3 different types of powers of attorney that do apply to a special needs situation. The first is the durable power of attorney. This is for when a person is or becomes incapacitated with such as a chronic illness or disability. There's no set time period, and it can last for as long as the person in question is alive, and it can be set to manage all affairs if that person is unable to do so. The second is a medical power of attorney. This is a power of attorney that offers specific control over healthcare decisions while the person in question maintains their own ability to take care of financial and personal considerations beyond healthcare. The third is a springing power of attorney, and this is a consideration for the parent. A springing power of attorney takes place or begins after a parent is disabled in some way or incapacitated. So what it does is creates an opportunity for someone else to take control or care for their child in their stead through this power of attorney. The next consideration is a special needs trust, which is also often called a supplemental needs trust because it takes care of or supplements the pieces that might be taken care of by other assistants. There are 2 different types. The first is called a first-party trust. A first-party trust is where the person who creates the trust, in this case the parent, is the only one that can make contributions to that trust. A third-party trust, which is the most common type for these situations, can accept contributions from anyone except the beneficiary. This means that grandparents, other family members, anyone that might be interested in contributing to the trust for your child is able to do so. The only person unable to make a contribution would be your child themselves. The other thing to consider is how you want that trust to be planned or built. It can be part of your will or estate planning as you go through the process of creating those things, or it can be a separate trust agreement that you make specifically for this child and for these needs, completely separate from your regular estate planning for the family. Continuing with estate planning, there are some things to consider here. The first is that you want to periodically review and or update your estate plan because things do change over time and you may not realize that some of those changes will affect your estate, and so it's important to discuss those with your attorney and make sure that things are updated so that they are always in a current state. The other thing is to consider what type of attorney you would like to work with. It makes sense to work with somebody who has experience in elder law or in fiduciary administration. This is because an elder law attorney must know about Social Security and Medicaid and state disability regulations, whereas other attorneys may not have this information if they focus on just civil law or IRS law, something like that. And a fiduciary administration attorney would also have a lot of this experience because what they handle is estates and wills almost exclusively. Other things that you need to consider with the will is if you want an executor, which is someone that you appoint to oversee or manage your estate for you. A will usually does three things. One is appoints this executor. Two, transfers property that you may have. And three, pays any debts or taxes that you may have outstanding at the time of your death. Additionally, you need to consider guardianship or alternative protections for your child. A guardianship can actually be filed without an attorney if necessary, so it can be filed by the parents or legal guardians. You simply go to the court and pay the filing fees and fill out some information. There are two different types of guardianship. The first is full, which covers all aspects of the person's life, and the other is limited, which authorizes for a specific purpose or circumstance, such as financial matters or legal matters, leaving them the ability to handle their personal matters. If you choose to not do a guardianship or to do a limited guardianship, there are other alternative protections that you can consider. The first is a conservator, which is also known as a financial manager. And in those instances, that would be a limited guardianship, and the child with the disability would be the one to take care of their personal matters. The next would be an appointed agent with a power of attorney. So this would be somebody for financial affairs as well. And the third is an advocate with privacy waivers. And this is what would be a HIPAA waiver. So this person would handle healthcare and medical concerns and leave the financial and personal matters to the person in question. So you could hypothetically have a limited guardianship to cover personal matters, an advocate to handle privacy and HIPAA matters, and an appointed agent or conservator to handle financial matters. But in those instances, you would be doing it in order to have three separate people covering each of those pieces versus a full guardianship with one person. In addition to the guidance and information that's been provided in this PowerPoint, we also have a list of resources here that you can look to for additional information, and that can also help you find people to assist you with some of the things discussed in the module and in this PowerPoint, such as finding a conservator, finding an advocate for privacy waivers, locating an attorney with specific knowledge such as elder law. Links for all of these resources listed here are on the module on the final resources page, and will take you straight to those websites so that you can find more information.